A broken business promise often feels personal, but the legal system's response is strictly mathematical. When a contract is breached, the law never steps in to punish the breaching party. Instead, the goal is pure restoration. This is called the expectation interest, a legal mandate to put the injured party in the exact financial position they would have occupied if the contract had been flawlessly performed. Courts do not guess at this number. They rely on rigid, established algebraic formulas to drop exact weights back onto the scale. To see how this works in practice, we have to deconstruct the standard measure, layer on consequential and incidental formulas, apply them to complex construction disputes, and define the legal caps that keep these numbers in check. Translating an abstract broken promise into a precise financial equation requires stripping away the emotion and focusing strictly on the math of restoration. The mandatory starting point for any damages analysis is the standard measure. This calculates the variance between the agreed-upon contract price and the reality of the open market. The sequence of this formula flips entirely depending on which party breaks the deal. When a buyer wrongfully repudiates an agreement, the seller is forced to find a substitute. The damages equal the contract price minus the new market price. If a buyer signs a contract for a $1,000 bicycle and then walks away, the seller must secure a substitute buyer. If the open market only yields $750, the breaching buyer is liable for the $250 shortfall. Now reverse it. A seller fails to deliver, forcing the buyer to secure substitute goods, a process legally known as cover. The formula is market price minus contract price. The buyer expected a $1,000 bicycle. If the seller breaches and the buyer has to pay a $1,500 market price to cover from an alternative source, the breaching seller owes that $500 premium. The standard measure resolves direct price differentials perfectly, yet it is inadequate for capturing the broader logistical mess left in the wake of a breach. A material breach creates a blast radius that extends well beyond the immediate contract price. The law relies on cascading damages to capture these secondary losses. The first layer is incidental damages. These cover logistics costs incurred inside the contract scope, things like storing rejected goods, return shipping costs, or broker fees paid to secure a substitute. The second layer is consequential damages. This calculates the secondary financial losses suffered outside the immediate contract, requiring a distinct formula: lost secondary revenues plus reliance expenses minus avoided expenses. Consider a caterer who books a $5,000 event, relying on a local fish market for a $1,500 seafood order. The market breaches, closing unexpectedly. The caterer scrambles and spends $500 on alternative fish, a reliance expense, but they avoid paying the initial $1,500 invoice to the breaching market. The short supply causes the caterer to run out of food mid-event, and the client refuses to pay the $5,000 fee. Plug in that lost revenue, and the total consequential damages equal exactly $4,000. There is a critical legal cap on this formula, established in the landmark case Hadley v. Baxendale. To recover these secondary losses, you must prove the harm was reasonably foreseeable to the breaching party at the exact time the contract was formed. The law will compensate you for the domino effect of a breach, but only if you can prove the breaching party could see the dominoes lined up when they signed the deal. Construction contracts represent the ultimate stress test for expectation damages. They require courts to aggregate all of these formulas simultaneously. Take a scenario where a contractor walks off a residential build after taking an initial down payment. The formula expands: the market price to complete minus the remaining contract balance, plus the down payment already paid. The owner signed a $150,000 contract, paying $50,000 down. The contractor abandons the site. Securing a new bid to finish the exact same house requires a market rate of $165,000. Run the numbers and the standard damage baseline equals $65,000. Now layer on the cascading damages. The contractor left unused materials out in the rain, adding $10,000 in incidental damages. The delay forced the owner to secure a temporary apartment lease, adding $6,500 in foreseeable consequential damages. This construction model proves that making a victim truly whole requires a multi-layered equation, one accounting for direct replacement, logistical salvage, and secondary fallout. You do not, however, automatically get the cost of performance. The justice system imposes boundaries to prevent plaintiffs from extracting unconscionable windfalls. This boundary is the doctrine of economic waste. In Jacob and Youngs versus Kent, a builder accidentally used the wrong brand of pipe inside the walls of a completed mansion. The replacement pipes were identical in quality, yet the owner demanded the cost to tear down the finished walls to swap them out. An even more extreme paradox occurred in Peavy House versus Garland Coal. A mining company breached a specific promise to restore the grade of leased land after extracting coal. The massive dirt-moving operation required to perform the fix would have cost $29,000. The financial disparity made this unreasonable. Performing that $29,000 restoration would have only increased the actual market value of the farm by $300. When the cost of performance is grossly disproportionate to the economic benefit, courts abandon the standard formula. They switch to the diminishing in value rule, awarding only the drop in market price. For the owner in Jacob and Youngs, that difference amounted to exactly zero. The justice system will actively deny the funds to fix a breached contract if executing that fix results in senseless economic destruction rather than actual commercial restoration. There is one final boundary capping these equations: the doctrine of avoidable consequences, widely known as the duty to mitigate. The law requires you to take reasonable steps to stop the financial bleeding. You cannot simply sit back and let the damages artificially inflate. But there is a narrow, fact-specific exception to this rule: the lost volume seller doctrine. The premise is capacity. If a party has virtually unlimited resources, securing a replacement contract does not actually mitigate their loss. They had the operational capacity to profit from both contracts simultaneously. Providers of personal services can claim this status. In the WorldCom bankruptcy, the telecom giant rejected a 10-year endorsement deal with Michael Jordan. Jordan argued that because the contract only required 16 hours of work a year, he had the physical capacity and intent to take on additional endorsements anyway. Mitigation aggressively caps recovery for standard businesses. True high-volume entities, however, are exempt. Forcing them to mitigate would rob them of a mathematically guaranteed second profit. Contract remedies exist at the tense intersection of mathematical precision and economic reality. The standard measure calculates the immediate price difference. Incidental and consequential damages catch the cascading financial fallout. It is the legal caps, foreseeability, mitigation, and economic waste that act as the ultimate guardrails, ensuring these equations deliver restorative justice rather than a punitive windfall. By mastering these formulas and understanding their boundaries, you can accurately map the financial architecture of any broken promise.